We're going to go over selective incorporation. So you should have your interactive notes on selective incorporation in front of you, and I want you to follow along as we go through. Note that you're going to fill in the blanks when you see them on the slides. I'll try to remind you. Usually it's stuff like written in red, so just keep an eye out for those things. But we're going to be talking about this thing called selective incorporation, which is, I guess, somewhat relatively new for the United States. I mean, we'll talk about it some more, and you'll have an idea of like why it's kind of new. It's really like this: the Civil War gets this kind of going, and then you have some cases. One case 100 years ago, actually, exactly 100 years ago, is the start of this selective incorporation. The selective incorporation is going to be important because it, in a way, because it's part of the 14th Amendment, it really has a lot to do with civil rights and the civil rights movement that's going to pop up in the 1960s. So let's get into it. So step one, we're talking about Congress shall make no law. And I believe this is an excerpt from the First Amendment, but what we're referencing here is the Bill of Rights. And so at the time the Bill of Rights was created, the founding fathers were afraid of a strong national government, not state governments, right? So in your notes, you're going to fill in that blank with state, right? Not state governments. And the Bill of Rights was originally crafted to protect people from the national government and not the states. So if you read through the Bill of Rights, all it is talking about is the national government, the national government. It's not talking about the states. And that's because many states had their own Bill of Rights. And so, Hamilton very specifically was like, we don't need a Bill of Rights because it's clear what the federal government can do. And then all of the states have their own Bill of Rights to protect their people. And then eventually they caved because they were like, okay, we need to get this thing signed, of course, compromise, we'll put the Bill of Rights in there. And so what kind of happens, we'll look at this Barron v. Baltimore case, but what they start to realize is that the protections in the Bill of Rights, because they're based on natural rights to a certain degree in English common law, they should apply to all people regardless of the state that they live in. So this Barron v. Baltimore case in 1833, so this is an important case because it sets the precedent that the Bill of Rights only restrained the national government. And so in this case, this guy Barron, Baltimore does a program where they build like one of the first like highways, essentially like a street that is publicly owned by the government, and it like cuts across the state to make travel easier and commerce easier. So Baltimore, the state, is doing this. Barron is a guy who owns a wharf where ships can load and unload, and it's up the river a little bit in Baltimore, and because it's so deep, you can get like really big cargo ships in there. But what happens is, in order to build this road for Baltimore, for Baltimore to build this road, they have to like cut and dig and drain streams and creeks and stuff. And so they're funneling water, creek water, streams into the bay where Barron's Wharf is, and as water is running through, it's also depositing sediment. And so over a period of time, the bay where the wharf is starts to get more and more shallow. And that is bad for Barron because now he can't take on those really large cargo ships. And so he's losing money. So he sues Baltimore, and they don't really bring up the Fifth Amendment, but initially they're kind of arguing that they should be compensated. So the mayor of Baltimore and the city council are sued by Barron, but they appeal after Barron's awarded, $4,500, I believe, in damages. And they're kind of arguing that the city, I guess it's the city in this case, but the city or the state has the authority to conduct public works on public land for the betterment of all citizens, and that this guy Barron should not have like he shouldn't be made a priority over the rest of the citizens. And so Baltimore's arguing, we can do this. It's for the betterment of society. So this guy should just can it. Barron doesn't like this, and they appeal to the Supreme Court eventually. And the case that comes up before them is like essentially, does the Fifth Amendment which prohibits like the taking of someone's property without just compensation. Does that prohibit like states and cities from doing the same thing? Like it says that they should be just compensated. And the Supreme Court, Chief Justice John Marshall, it's his last decision, and he writes that this was an important case, but it was also an easy case to decide. And they decided that the Fifth Amendment only applies to the national government. So time marches on. And that Barron case is actually a really big motivator to pass the 14th Amendment in 1868. You will remember that the 14th Amendment is one of 3 amendments that are passed during the Civil War, or passed during the Civil War or put out during the Civil War, and then after the Civil War they're ratified. The 14th Amendment was added to the U.S. Constitution in 1868, and there's many parts or clauses to this amendment, and it says that no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law. So this wasn't here for the Barron case, for the Barron v. Baltimore case, which if it was here, then Barron would have a point, right? He would have a point that the state or city is depriving him of property. And there needs to be due process and therefore just compensation. And due process means to be treated fairly and equally by the laws. So you might think about the deportations currently occurring, where because this is the argument set forth by the federal government, that because the people who are being deported are not only foreign nationals but are in the country without proper documentation, that they are not awarded then due process. So there's a big argument about, is due process for just citizens, or it says any person, right, in the 14th Amendment, deprive any person of life, liberty. So big debate right now on that specific piece of the 14th Amendment. And then, of course, the citizenship clause of the 15th. So let's continue. Time marches on, and we got our first look at how the 14th Amendment is going to actually impact the Bill of Rights. And so step 3 here, 1925, Gitlow v. New York. So Gitlow, surprise, surprise, is charged under a New York statute that made it a crime to advocate the overthrow of the government through force or violence. And so you'll notice that it's a New York statute, so it's a state statute, where it's a crime to say that you want to overthrow the government by force. So he and the attorney sued, and they're arguing that the precedent of Barron v. Baltimore was wrong. And they can only do this because of the 14th Amendment. Barron v. Baltimore, I think, probably was right in the sense that there was no 14th Amendment at the time. It's 1833, right? Fast forward, 1925, Gitlow v. New York is the first case of what is called selective incorporation for First Amendment rights, in this case, to be applied to states as well as the federal government. And so selective incorporation is the process of selectively incorporating amendments from the Bill of Rights, which were originally only protections against the national government, the federal government. Selective incorporation applies that Bill of Rights to the states as well. So states can no longer deprive people of First Amendment rights because, again, things in the First Amendment, the Founding Fathers, and the Bill of Rights are in many ways natural rights. They're rights that people think should be afforded to all peoples regardless of who they are. All people are born with certain, unalienable rights, to quote the Declaration of Independence. So the First Amendment is applied. However, this is a clause-by-clause thing. So while selective incorporation in Gitlow v. New York is the First Amendment right to free speech, in this case, there are going to be other selective incorporation cases for the other clauses of the First Amendment. We've already looked at some of them, Wisconsin v. Yoder and Engel v. Vitale, the two that incorporate both clauses of the religious freedom piece of the First Amendment. And so the court's decision states that 14th Amendment due process and equal protection clauses mean that the federal government can enforce the Bill of Rights on states. So states can't have, they can't do whatever they want because these things are rights that all people are afforded. So our core concept for selective incorporation, this is that before the process started, the federal courts, they had little to say about day-to-day operation of state and local governments, right? We had, think about the issue of federalism that we studied towards the end of Project 1. We had the layer cake and we had the marble cake. This is a very specific example of dual federalism, of federal courts really not having anything to do with the state and local government courts or the state and local governments at all. But now we begin the process of marbleization, of creating that that cooperative federalism piece that we had looked at earlier in the semester. And selective incorporation, again, is the enforcement of each amendment at the state level, but they are incorporated one amendment at a time. So it's a long process and it takes a long time, right? This is Gitlow v. New York, the very first one, and the first one for the freedom of speech. But we get another one. I think Wisconsin v. Yoder is the 60s. Engel v. Vitale is the 60s. It happens one at a time, and it takes a very long time to get there. So let's look at some of those cases that come up a little bit later, right? So time marches on. We talked about this one, Mapp v. Ohio. This was the lady who was hiding a fugitive, like a mobster in her place, and they found in her where she was living, they found ticket stubs that looked like illegal gambling activity, and so they seized it as evidence and prosecuted her. So in this case, Mapp v. Ohio, 61, the court ruled that the exclusionary rule of the Fourth Amendment applied to the state governments as well. So they couldn't just find random evidence and bring that up as something to convict this person. They had to actually have reasonable suspicion and to get a court warrant to look for those things. So in this case, this was good, good for her. I don't know what came of this case, but sometimes these court cases are like, okay, well, you couldn't do it that way, but obviously she was hiding a fugitive and they found the fugitive. So that probably doesn't bode well for her, for being honest. Another example, Gideon versus Wainwright, talked about this one. This guy was supposed to have been given counsel, even though his case was in Florida at the time, and Florida's law was that Florida doesn't have to give you a lawyer unless it is for a capital offense, meaning you're facing the death penalty. And so for Gideon, he read up on the issue of the 14th Amendment, and the court agreed with him that the Sixth Amendment's guarantee to counsel is a fundamental right and essential to a fair trial. And so the due process clause of the 14th Amendment allows Gideon to get defense, get counsel. If he cannot afford one, the state will appoint one for him. That's 1963. And then the next one that we've got, fast forward, 2010, McDonald v. Chicago. Not that McDonald. You'll notice that this is not the restaurant chain. Here the court ruled that the Second Amendment's right to keep and bear arms for self-defense in one's home is applicable to the states. So it's a lot harder now for states to pass Second Amendment restrictions or gun control measures from the McDonald case because the 14th Amendment makes the Second Amendment apply to the states as well. So states will then have to do things like create background checks and restrict the amount of ammunition that you can purchase. Yeah, you can own a firearm, but you can't purchase as much ammo in a specific period of time. So like the New York State Pistol and Rifle Association case for Task 2, is a step toward, or it's responding to this McDonald v. Chicago case, right, in 2010, where does New York's law violate the Second Amendment, that you have to show need to have a concealed carry permit. So this McDonald v. Chicago case selectively incorporates the Second Amendment. And then here's our last one, Timms v. Indiana. Nope, not Tim's like the boots, but this guy Timms. So this case, the Eighth Amendment protected you from excessive fines. And this is incorporated against the states. I don't remember the specifics of this case. You can obviously go look it up for yourself. It's in 2019. But this is very recent within all of these, I think, are, well, most of these are within your lifetime. This one for sure. And the opinion is written by Justice Ginsburg, but it was a unanimous decision. I think Clarence Thomas had it's a unanimous decision. However, Thomas did not join the majority opinion. He probably wrote a concurring opinion, meaning he agreed with the ruling of the majority, but he had something else he wanted to say. And the Due Process Clause selectively incorporates the Eighth Amendment's protection from excessive fines and punishment. All right, so that's selective incorporation, guys. Make sure you also do the reading review on selective incorporation, just so that you really understand this, because this is such a key part of what we're trying to get out of the Supreme Court cases, but also it's a really important part for the movement of civil rights, because the 14th Amendment says that states can't deprive people of certain freedoms. And so what we'll find is in the 14th Amendment, the fact that, or the ability for people to say, hey, I'm not getting due process or equal protection from my states. I need help, and appealing to the federal government to clamp down on the states. So that's it. Make sure that you fill out the notes, go back, get it all down there. This is, again, pretty important, crucial stuff for us.